Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, and I do probate, and I do it well. Today I wanted to talk to you about the importance of knowing whether or not your probate estate has creditor claims before you open it. But before I do, I invite you to schedule a free strategy session with me at eldermeeting.com. So as I mentioned in my intro, I do probates here in Florida, and many times I inquire in my intake process whether or not you or the family knows if the decedent or the person who passed away owes anybody money, right? Will there be any creditor claims, particularly if the person has been dead for less than 2 years, because the statute of limitations on the creditor's claims in Florida is 2 years, meaning if a person passes away and owes debt, the people who are owed that money have 2 years to open a probate on behalf of the deceased person and seek to collect payment, right? So anybody in Florida could open the probate. It could be a relative, right, a family member, or it could be a creditor. So a creditor themselves can open a probate estate on behalf of somebody who owes them money. So with that said, one of the reasons why I ask families or people who are named as personal representative in the will, whether or not if they know whether or not there's money owed, it's because when we are making a business decision to determine whether we should be opening the probate right now in an effort to get everybody their inheritance and transfer assets and make things available to be sold, or if we should be waiting out the creditor period, we want to know how much money is owed and how much money is in the estate, so that way we know how much money would be net, right, in inheritance to those who would be entitled, either pursuant to the will or pursuant to the laws of intestacy, right? And sometimes families come to me and say, no, there's no debt. They didn't, all their medical bills were covered by insurance. There's no debt. And then we get these ugly surprises where we have a large claim filed, $80,000, $100,000. Many times those size claims are filed by Medicaid, which is the government-based insurance where they are entitled to reimbursement from a probate estate. And their relatives and their family members were adamant that they were not a Medicaid recipient. But not everybody tells their family members their business, right? Not everybody tells them that they are a Medicaid recipient. And so they just didn't know. And now they're hit with this really big claim, and the estate may not even have assets enough to cover it, right? And it's really unfortunate when that happens. Obviously, there's some monies that I'm able to try to shelter and protect, and still have monies that are able to be transferred, within the family, like as an exempt property and things of that nature. But other times, monies that they thought were in the bank coming to them are now eaten and dissolved by creditor claims. And that's so sad. And one of the things that we can do, if somebody wanted to do some due diligence before they open the estate, is to make a request to entities like Medicaid to determine whether or not they have a lien on that person's probate estate before you decide to open it. And then at least then you will know that there's monies owed and the approximate amount that could be anticipated, so you can make an informed decision whether or not you want to open the probate right then, or if you want to wait out the claim and open it up after the passing of the 2-year creditor period. I hope that this information has been helpful to you. If it has, I ask that you like and share with others. And as always, thank you for joining me.